So was this at all a difficult decision for the South African government to take?
Well, the very fact that it took us this long to arrive here speaks for itself. But it was not just a question of difficulty, it was also a question of process. You'd recall, for example, that at the agency of the ANC last year, in taking the decision that South Africa should seriously consider withdrawing, certain steps were prescribed or were suggested that needed to be exhausted before we arrive at this. Amongst them, engaging at the AU level, engaging at the ICC level, all of which was done, and it was a journey to arrive at this point. And of course, also pursuing recourse through the judicial processes. So those steps did take place and preceded the final decision in this regard.
The chief prosecutor of the ICC had previously indicated that it will be a sad day for Africa to leave the ICC, to withdraw its signatureship from the Rome Statute. We've seen Burundi has now taken this decision, and now South Africa has taken this decision, and it almost seems that it will have a ripple effect, considering that the AU has also taken a stance with regards to the ICC. Would you agree with the sentiments that it will allow for impunity for those in leadership positions, heads of states, to act with impunity?
Well, what options do you have? Do you resort to regime change? How do you achieve regime change? Do you invade a country, send your soldiers there to take out a sitting head of state? Or do you invite a head of state under the pretext of peaceful interaction, and upon their arrival here in good faith, impound on them, arrest them, and prosecute them, and effect a regime change in the country? You tell me. What is your opinion?
Would South Africa have reconsidered its position had the ICC agreed to relook at the obligation that its signatories have, whether to arrest a head of state who a warrant has been issued against? If the ICC had said, okay, let's relook at this and let's not arrest heads of state, considering the conflicts that might arise from that decision to arrest a head of state. We've seen what happened in Kenya, where you had Uhuru Kenyatta, who subjected himself to al-Bashir, who decided not to do that. If the ICC had decided that let's relook at that clause, would South Africa have been amenable to that?
Well, that was a central objection. That actually our understanding was that it is possible to interpret the law in a manner that harmonizes a dispensation that affords diplomatic immunity on the one hand, as has indeed been recognized by the judgment in the SCA on the one hand, and of course our obligations or countries' obligations under the Rome Statute. Had that been achieved, it would at least have removed one obstacle, or the central obstacle, for us, for our continued participation there. Of course, there's been other issues about who gets to be targeted, who gets to decide who gets to be targeted, and those issues. But I think the primary issue is this legal question of interpretation, which continues to be one of the central features that influenced our decision in this regard. Similarly, under our domestic law, had an interpretation of our domestic law gone the way of seeking to find some kind of harmony between the two obligations which flow from the application of international law, namely customary international law dealing with diplomatic immunity on the one hand, as domesticated in 2001, and of course in 2002 on the other, the domestication of the Rome Statute. Had the courts found some harmony in interpreting the obligations of the state under both regimes, perhaps that would have obviated South Africa's withdrawal and pursuit of a repeal of the domestication law.
Looking at some of the reaction on social media at this point, some saying that this decision by South Africa flies in the face of its obligation to uphold human rights. And Minister Michael Masutha, what was your message to the victims in Sudanese, those who have suffered under the leadership of Omar al-Bashir at this point, who say that South Africa has failed them yet again?
Do they believe that forced regime change in the manner that we were sought as South Africa to be the guinea pig and the first country on earth to have effected would have advanced their cause as Sudanese citizens? I ask the question back to them. Do they believe that the arrest of President al-Bashir and his prosecution and possible conviction, if that was to arrive at that, and incarceration would have advanced the goals of peace in Sudan and would have led to sustained peace in the Sudan and avoided any further bloodshed and suffering that has already occurred? I ask them that question, and they must provide the answer as Sudanese people, which they're best placed than us as South Africans to answer.
Do you think that South Africa was at all too hasty in making this decision, considering that during the Q&A you couldn't answer whether those who were party to allowing Omar al-Bashir to leave the country would be liable for that decision, whether any criminal action could be taken against them?
You cannot place possible personal liability arising out of a possible finding of non-compliance with legal obligations to supersede our national interest and our international obligations, which would have far more and far-reaching implications, not only for our country, but for the affected country, that would have resulted possibly in the loss of many lives, as well as perpetual instability in those countries. We have seen where regime change has been imposed, what the consequence is: lasting instability, lasting turmoil, lasting conflict, and the loss of many, many lives. It does not help anyone.
Final question. The DA has indicated that they will challenge this decision by Cabinet. Just a quick reaction from your office?
As I've already indicated, it is the prerogative of every person under our Constitution and Bill of Rights to have their legal dispute resolved either in a court of competent jurisdiction or appropriately qualified judicial tribunal. So if it is their choice as a political party to pursue that route, they are perfectly within their rights under our Constitution.
And you stand by this decision?
And of course, as a Minister of Justice, I would be the last person to seek to discourage or impede citizens' rights to exercise their rights under the Constitution and Bill of Rights.
Well, thank you so much. That is the Minister of Justice, Michael Masutha, indicating the decision that has led to, the discussions that has led to this decision now to withdraw from the Rome Statute. And seemingly it seems that the one clause that broke the camel's back is the one that South Africa or any signatory to the Rome Statute has an obligation to arrest any head of state who has a warrant of arrest against him. It's back to you in studio.